If you do not like someone's story, write your own. Changing Narratives with Wambui Kabage.
Hi everyone, this is Wambui Kabage. Today we will be discussing matrimonial property. Very sensitive conversation. So here's the thing, guys. I'm going to take you through a little bit of history so that you understand where we've come to. With matrimonial property, there was this consensus that at the end of the day, the husband was the one, especially if he has title over the properties, that generally he's the one who had entitlement to the property and he was going to go away with it. So what happened, because we are a British-based system and we take our law from the UK, the judges in the UK recognized that there was actually a very unfair thing that was happening, which was essentially women who had been married for a very long time and who were divorced ended up with pretty much nothing after 20 years or more of being married to these men. An interesting judge called Lord Denning, who believed in the idea of equity, which is fairness, came up with this idea, which is he needed to, in law, create proprietary rights, essentially meaning trying to find a way to give these women legal rights over property. And what he did was he came up with two concepts, which was constructive trust and resulting trust. So, okay, guys, let me explain constructive and resulting trust. So the constructive trust was where Lord Denning recognized that the woman, for example, may have done some form of interior design, and the result of that was, of course, an increase in the value of the property. Or she did something at the home, and quite frankly, just being in the home, taking care of the children was something that Lord Denning felt must be recognized. And really, logically, it should be recognized. There needs to be a formula, but folks, right now, there is no formula. Then the resulting trust is where we're talking about this woman actually taking finances from her savings and putting it into the property. Right? And yes, there's probably no formal kind of recognition of that, but he recognized that as a result of that, he was able to purchase a property, which means she did create some form of proprietary right over the property and therefore needed to be compensated for that. Now, the thing is with Kenya, we bounced a lot for many years over this conversation. Quite frankly, we're still probably bouncing up and down on this conversation because it's such a charged conversation, right? And most recently our courts decided, this is before the Constitution came in, the courts decided that yes, there has to be some acknowledgement of the woman's role in this relationship and the participation that they've done with the property. And so there were calculations. So sometimes it flip-flopped between 30-20, 30-70, and sometimes it was, wow, if you got a progressive judge, this was like a 50-50 conversation. And at the end of the day, it bounced between the High Court and the Court of Appeal. Really, it became very charged, and especially if you're dealing with, the upper class who have a lot of property and they really, at the end of the day, don't want that property disrupted. There was always an undertone and a resulting judgment that reflected the sentiments of the time. Now, the purpose of the Constitution that came in 2010 was to try and equalize that playing field. Under Article 45 of the Constitution of 2010, it stated that a married couple had equal rights at the time of marriage, during marriage, and at the time of termination of a marriage. What does that mean? Well, exactly. So right now we're in a situation where there is a case, and the court decided that unless a woman could prove some level of contribution, this argument that the Constitution created a 50-50 division was not acceptable. This decision was appealed to and went to the Court of Appeal, and the Court of Appeal said that actually the Constitution provides that there is a 50-50 split, right? Obviously, the man was not happy, and now this matter has been pushed and is going to the Supreme Court. What does that mean? It means that even today, even after the Constitution, we are still flip-flopping, right? There is no complete definition of that section. And so, guys, when you go to the courts and you're arguing about matrimonial property, you're likely to fall victim of this same conversation. Now, my proposition is mediation. And the reason I talk about mediation is because, guess what, guys? Mediation dissipates this hostility. It brings this conversation to a human level, whereby a couple that have genuinely been in a relationship, that have property together, are able to sit down and rationally, without hostility, without anger, have a conversation about this property, right? If this woman participated, for example, in the interior design of the home and therefore increasing the value of it if you were to put it in the market for example, rent, right? That has to be recognized. And really at the end of the day, that conversation can be had within a mediation context. It certainly cannot be had productively in the courtroom. So you see, guys, for me, at the end of the day, the reality is this: matrimonial property is a hot topic, but it only gets worse when we decide that we're going to put this before the courts, whom, by the way, are conflicted as well. So really, I recommend strongly that when you go through a divorce, before you go into court, please have a conversation about matrimonial property and the division of it in a fair and equitable way. Guys, listen, you know when somebody contributed to something. But, you know, when there's bravado in the courts, you're going to lie. That's pretty much how it goes down. Anyway, guys, I hope this has been beneficial. Like, share, and subscribe.